new and improved Supreme Court Advisory Committee. As you know, or most of you know, I'm the chair of this committee and have been for over 20 years, which is hard to believe. But apparently, I haven't messed it up too badly, so I'll be here for at least another 3 years, which is our term. We've got a lot of new members, and I think it would be great if they could just tell us a little bit about themselves. And I've got their bios. Many, if not most of them, I know and can vouch for them, but I don't know everybody. And Shiva, who is off camera here to my right, is our new assistant, succeeding Marty Walker, who retired. Although I received, Can everybody still hear me?
Yes.
Okay.
Yes, I think somebody shared a screen.
Yeah, somebody shared a screen. So Marty retired, although I received a call from a judge who will remain nameless, asking for a reference for Marty. So she may have decided to leave Jackson Walker and go to a different sort of job in post-retirement period. But in any event, let me call on some people who are new to our committee and ask them if they'll just introduce themselves and tell us a little bit about themselves. And I have them not in alphabetical order, but rather in the order that Shiva gave me with their bios, which is totally random as best I can tell. So the first on the top of my list here is Connie Pfeiffer from Yetter Coleman. Connie, are you somewhere out there?
Yes, I am. Looks like I'm one of the two on video.
There you are. All right. Now, first, we think you should do a musical introduction. So go back to the piano and play a couple of bars for us. Now, go ahead, Connie. Tell us a little bit about your background, if you don't mind.
Sure. So I'm an appellate partner with Yetter Coleman here in Houston, and am brand new to this committee. So I don't know if I'm first up on the line today, but very happy to be a part of this and interested in the work of the committee.
Great, thanks, Connie. The next two people on my list I do know, and they are both rascals of the first order. But the first is Chris Porter. Chris, I saw you somewhere.
Yes, hi. Chris Porter. I am a trial partner with Quinn Emanuel. I was at Yetter Coleman for almost 9 years before that. Unfortunately, I did not get the good fortune to overlap with Connie, but we still remain friends nevertheless. I'm very excited to be a part of this committee, and thank you all for having me, for providing me with the opportunity to join you.
It's great to have you with us, Chris. Thanks.
Thank you.
The next is John Kim. John, you around?
I'm here. I'm John Kim. I'm a small firm practitioner in Houston. I do all trial work, a little bit of appellate, but I do both sides, both plaintiff and defendants, and I'm looking forward to participating in the process.
Great. Thank you, John. Next, the county clerk, John Warren. John, if you're here.
Yes. Good morning, everyone. Yes, thank you very much, Chip. As my name is John Warren, I'm the county clerk for Dallas County. This is my 16th year as serving as county clerk. Prior to that, I was with Dallas County Courts as a court administrator and a systems administrator for 13 years. And prior to that, I worked in the federal court system. So pretty much all of my adult career has been in courts at some form or another. So I'm looking forward to learning as well as assisting this committee in achieving its goals.
Thank you so much, John. Next, we have Judge Emily Miskal from Collin County.
Hi, I'm Judge Emily Miskal from Collin County. I'm a district court judge, and during the past year or so, I've been especially involved in some of the remote trials and technology issues. I also serve on the Computer and Technology Council for the State Bar, so that's what I've been paying attention to lately.
Great. Thank you so much, Judge, and nice to have you with us. Next up is Manuel Bareilles from Vincent and Elkins. Manuel, are you around? Well, I may have to stand in for him then. Manuel is a trial and regulatory enforcement lawyer who represents businesses and individuals in a wide range of litigation and investigation matters. And his resume goes on and on.
He just joined right now.
Oh, Manuel, did you just join? No? Okay. Next up, Richard Phillips from Thompson Knight. Richard?
Good morning, everybody. Rich Phillips, as you said, a partner at Thompson and Knight. I clerked on the Supreme Court about 20 years ago, so I appreciate the fact that although Chief Hecht knew me then, he's still willing to let me be on this committee, and looking forward to the opportunity to work with everybody.
Rich, he tried to veto you, but Justice Bland and I said we weren't having any of it. So
well, I very much appreciate that.
The last one on our list is Judge Robert Shaffer, well-known judge to me and to many of us from Houston. Judge?
Thank you. Good morning. I'm Bob Shaffer. I'm judge of the 152nd District Court, a successor to my friend Harvey Brown, who's also on this esteemed panel. For the last 12 years, I've been judge of this court. For the last 8 years, I've been the local administrative district judge of Harris County. And before that, I spent about 20 years as a solo practitioner here in Houston.
Thank you, Judge. Next up is Judge Kathleen Stryker. Judge, are you here?
I am here.
Great, there you are.
Good morning. My name is Kathy Stryker, and I'm judge of the 224th District Court. I've been on the bench since 2011, handling family and civil matters. And before that, I was a partner in 2 different firms here in San Antonio. And I'm super excited to be on this committee.
Great, thank you, Judge. And the last one I have on my list is, last but not least, is Judge Maria Salas Mendoza from El Paso. Judge, are you here?
I am. Good morning, everyone. It's earlier here than it is there, so I know my lighting keeps going off. I may have to add some lighting here. I'm the judge of the 120th District Court. This is my 15th year on the bench. Former administrative judge of the council here in El Paso. I'm on various committees, and I'm excited to be here, hopeful that I can add some value to the committee.
Judge, thank you so much. And you should know that for a number of years, decades really, we have been cursed with having only Richard Munzinger as an El Paso representative on this committee. And it's great that we now have somebody else who can represent our westernmost city and different time zones. So welcome and thanks for being here. On a more serious and sad note, the people who are holdovers from past committees will no doubt remember Frank Gilstrap. Frank used to always sit 3 or 4 people to my right in wherever we met, whether it was at the TAB or at the bar. He had incredible insight, incredible energy, great humor, and he was just a fabulous colleague to all of us. He passed away a few weeks ago, and there have been tributes from many of the members of the committee that have been circulated among the old committee. Your newcomers probably didn't get to see them. If you didn't know Frank and didn't get to practice with him, not only on this committee, but in the practice of law, you missed something. He was a terrific advocate, smart as a whip, one of those rare lawyers who could entertain and convince a jury, but then defend that jury verdict on appeal. He was both a terrific trial lawyer and a terrific appellate lawyer, and there are not too many people that can bridge that gap between trial and appellate. We're going to miss Frank tremendously. I know I will. And I thought in tribute to him, and it's a small one, but perhaps we could have a few moments of silence in our virtual meeting here. Thank you. I hope everybody spent those few seconds and with fond memories of Frank to the extent you knew him. I wanted to tell, for the benefit of the new members, a little bit about our format and rules to the extent we have any rules, which we really don't. The format is I try to start these things on time at 9 o'clock. We will take a morning break of 15 minutes. When that break occurs will depend a little bit on where we are in our discussion. At somewhere around the noon hour, we will have a 1 hour lunch break, sometimes less in this Zoom era, but when we're meeting in person, an hour. And then when we start up again in the afternoon, we'll take one afternoon break, again, dependent on where we are in the discussions. It will be 15 minutes. And then we will conclude at 5 o'clock, no matter where we are, because some of us need to get to the Four Seasons to have a drink at the bar. Just kidding about that. We sometimes meet for a half day on Saturday. If our agenda is very, very heavy, which it is not today, but sometimes we need to meet that extra half day, and we'll try to give you as much notice as we can. We also will endeavor to get you an agenda in advance of this meeting and much farther in advance than we did today. We're struggling not only with a new committee, but there's some new assignments. And Shiva and I are just working through how to organize this. So thanks for bearing with us today. Hopefully we'll get better next time. Finally, we really don't have any rules, but the one thing I'd like everybody to keep in mind is that, as our name suggests, we are a Supreme Court advisory committee. We give advice to the Supreme Court. Sometimes they take it. Many times they do not take it, which is fine. Don't get offended by that. Sometimes they don't act on our advice, and that's okay too, because we're here to serve the Supreme Court. Before I took over as chair, there were some people thought wrongly that they were the Supreme Court. And that whatever we did, the court had to just follow in lockstep. The court proved that theory wrong multiple times, but it's not a good mindset. So I've tried to encourage everybody to recognize that we're just advisors. Just like a lawyer will advise a client, the Supreme Court is our client, and we advise them on what we think is the proper way to approach matters. With respect to the matters we consider, before I took over as chair, the advisory committee would consider anything, whether the court was interested or not. If a lawyer from Spring wrote in and said, "Hey, I've got a problem with Rule 52A1," the Supreme Court Advisory Committee would study it and come up with a recommendation. That occurred to me. It was not a good use of our resources. So Now, if the court wants us to study something, we will study it, but otherwise we won't. Now, a lot of times members of this committee have ideas about ways to improve the rules. And we sometimes, as members of this committee, have people outside the committee call us or write us and suggest changes to the rules. It is totally appropriate to send that to either to me or to the chief or to Justice Bland and say, hey, here's something that might be worthy of study. If the court feels that it is worthy of study, they'll let us know, and then we'll spend our time and resources on studying that issue and reporting to the court. We are broken down into subcommittees, generally divided by the rules of civil and appellate procedure. And those subcommittees do a lot of the really hard work in terms of studying and recommending the things that the court is interested in hearing from us about. The subcommittees will report at the full committee meetings like this one, and we will have a full committee discussion. And if this group is anything like past groups, we can argue about and talk about anything, even like whether E comes after A. There's been some disputes about that, about the vowels, A, E, I, O, and U. And I see Ms. Newton is laughing because she knows exactly what I'm talking about. But I will tell you in concluding this part of the agenda, this is professionally the best thing that I do. And I get the most reward out of the day or day and a half every other month that I get to spend with you all. I learn a lot. I also learn how much I don't know, which is humbling, but nevertheless fun. We start out every meeting with a report from the Chief Justice, who is our liaison to this committee, followed by a report from the vice liaison, the liaison in charge of vice, which is Justice Bland. So to that we will turn right now. Chief, do you have anything for us?
Yeah, Chip, thanks very much. And thanks to all for joining this morning. Let me introduce our rules staff at the court. Jackie Domery, who's on screen too, is the rules lawyer at the court, and she works on rules matters full time. Martha Newton is a former rules attorney at the court and is now my staff attorney, and she helps us extra with whatever we need. And Pauline Easley is a paralegal who does a lot of the work for us as well. The committee has been in existence since 1940. It was formed right after the statute passed, giving the Supreme Court authority to promulgate rules of civil procedure, and it has continued in existence every year since. It's taken a few different forms over the years, but it's never ceased to function. I've been the liaison to the committee. You may know that we divide up our administrative responsibilities on the Supreme Court into what we call liaisons, and that designated justice is the go-between, if you will, between the group and the court. I've been the liaison to the advisory committee since I've been on the court for 32 years. The advisory committee is just absolutely indispensable. And as Chip just said, there's a lot of tire kicking. In fact, we give tire kicking a whole new meaning on the advisory committee. But the good thing about that is whatever path the court ultimately has chosen to take over the years, it has never found that the advice that it was given by the committee was lacking in any respect. We could always know that we could go back to the transcripts and see that matters were thoroughly discussed that when there were concerns, they were completely considered, and the product that we got, we can depend on, that it has been vetted through and through. So that's what we look for from the committee, and we are so grateful that you're willing to give your time and energy to help us with that. I'll just mention that Professor Dorsanio was recognized in our order reconstituting the committee as an emeritus member. If you know Bill, longtime civil procedure professor at SMU Law School, he was appointed to the committee in 1982 and has served it for 39 years. And that's not our longest serving committee member. Buddy Lowe has been on the committee since the 70s. I don't think Buddy could be with us today, but he's a lawyer in Beaumont. But over the years, we've had a lot of extraordinary talent helping us, and this rules of the game in Texas wouldn't be in as good a shape as they are if it hadn't been for the committee's input. So now just a couple of things about what the court's been doing since the last committee meeting. On the law side, we finished oral arguments for the term and are on track to clear the docket of argued cases by the end of June. So this is a very difficult time for us, and everybody's working really diligently to get everything done. We've been teleworking for the most part throughout the pandemic. The legal staff has been mostly, and most of the judges have been as well, but it hasn't affected the quantity or quality of the work as far as I'm concerned. And I think while we're all looking forward to getting back into more personal settings more often, the teleworking has served us well. We've had several emergency orders, and I'll just mention a couple of them. We're continuing the eviction diversion program. We've got an order setting out the procedures for asking to be to take part in the program. Governor Abbott created it as a pilot back in the fall, and now it's a full-blown project. There have been some administrative difficulties in getting the money out, but there is a lot of money, over $1 billion in federal funds, and we'll be working to make sure that that gets to landlords and tenants in the weeks and months ahead. And the order just provides procedures for doing that in the JP courts. Our general order is now Emergency Order 36. It continues the flexibility that we've given courts from the beginning by virtue of the court's statutory authority to act in disasters. And since the beginning, we've shifted from more central control of the kinds of tools that were available to judges to more local control, and that's especially important now as we return to jury trials. I know Judge Shaffer in Harris County has been working with the judges down there to try to open courts more regularly to in-person trials. And judges are doing that all over the state. So for a while, we asked judges to clear all of their plans with the Office of Court Administration. But we no longer ask them to do that. We ask them rather to clear their plans with their local administrative judge and sometimes their regional presiding judge. The regional presiding judges through the pandemic have just been absolutely wonderful. Judge Estevez is on this committee, and all of those judges have worked so hard to help our 3,200 judges in Texas weather the storm of the pandemic. So the court is very appreciative of their efforts, and now to all the LAJs across the state who are taking on the same role. The new order provides that courts must allow remote participation to every participant other than a juror. And courts don't have to require social distancing and masks, but they can. We're going to leave that to their good sense as conditions continue to change across the state. We encourage courts in EO 36 to use reasonable efforts to conduct proceedings remotely, and we'll talk more about that a little bit at this meeting, but also in the weeks and months ahead. And the court may hold in-person jury proceedings if certain requirements are met. So I won't go through the details of the order, but I just call it to your attention. And the idea of the change is to just take more into account the local circumstances and the ingenuity and the diligence of our local judges in trying to proceed in their own court settings. EO 36 continues to allow remote jury trials, and we've had a bunch. I think we've had about 50 on in-person jury trials. From March of last year through March of this year, we had about 230. We ordinarily have 186 a week. So you can see we're pretty far behind. And the Supreme Court has asked the legislature to provide funding for visiting judges if we need that, to try to help work through the backlog that we anticipate will be there. Texas is a leader in the country on remote proceedings. And I know that because I'm president of the Conference of Chief Justices. And so I kind of have a ringside seat to what other states are doing. We've had over 1.3 million remote proceedings in the last year with 4 million participants. And we see this going forward as being something that we need to continue to take advantage of. The Supreme Court has appointed a remote proceedings task force chaired by Chief Justice Tracy Christopher, the 14th Court of Appeals, and vice chaired by Judge Emily Miskal, whom you just met a few minutes ago. And they have done an amazing job of going through Texas statutes, trying to identify what helps and what impedes remote proceedings. And there's some legislation pending on this, but we anticipate in the months ahead that we will come up with a more comprehensive procedural setting for remote proceedings of all various kinds in urban courts, in our rural courts, what works, what doesn't, and try to preserve what we've learned in the pandemic for whatever the new normal looks like. But also take a hard look at both the efficiencies and the difficulties of remote proceedings. And the committee will be asked to participate in that. On another matter, we gave the first ever uniform bar exam in Texas on February 23 and 24, right in the middle of the winter storm. I don't know what God's got against the bar exam, but it's very difficult. It's been very difficult to conduct the bar exam the last several times. But the Board of Law examiners managed makeup sessions and tried to accommodate everybody during that difficult period. We've promulgated the changes that the committee recommended in Rule 145. We've got comments back. There's some legislation pending about the rule. And so we will continue to look at the comments at the legislation and expect to have a final Rule 145 by the summer. There will be a Supreme Court hearing, public hearing for the first time ever on May 4th on the changes in the disciplinary rules. This is the result of a procedure adopted by the legislature for changes in disciplinary rules. And once they're voted on by the lawyers, the court is directed to hold a public hearing on them. And so that will be on May 4th. And of course, it will be by Zoom, but it will also be recorded and placed on our YouTube channel. And we've finalized several sets of rules at the end of the year, changes to the expedited action and discovery rules, which we received a lot of comments on, changes on the rules of substitute service or citation, changes on the panel rehearing rules. So we're working on all of these rules projects that the committee has had for a while. The governor was not asked to give the State of the State address in the House chamber as he usually is because of the pandemic, and neither was I asked to give the State of the Judiciary address there. But we recorded it, and I tried to go through in that address and touch on the various different efforts, initiatives, challenges that the Texas judiciary is confronting at this point in our history. Of course, the legislature is hard at work and closing in on the end. So the veteran members of the committee will remember that since 2003, the legislature has been very comfortable in directing that this committee and the court flesh out initiatives that are the subject of statutes to make them effective and workable in the courts and for lawyers. So we worked very hard for years with the legislature to have that kind of partnership because the legislature simply does not have the time or the focus to get into the details of how the rules of civil procedure and other rules governing the functioning of the judiciary should work. And so it really falls to this committee, once we have policy issues decided by the legislature, to then figure out the best way to make those effective in our, to implement them in our procedure. So there are a number of bills. Some have gotten quite a bit of attention, like the Court of Appeals redistricting bill, which has now been pulled down and won't be advanced further in this session. But we have lots of other bills there, some involving bail reform. The Omnibus Court bill will require some rules changes, and there will likely be other bills that will pass that will, again, as has been happening session after session, call on the court to implement through rules. So some of those are on a tight time frame. Sometimes the legislature asks that they be in effect by September the 1st after the legislative session. So that's pretty quick. Most of the time, there's a little more time to get them done. But if we have those, then we'll be looking at those hard in early June as soon as we can, and trying to come up with recommendations to effectuate those bills. Jackie Domery, whom you met, our rules attorney, follows all this legislation as it develops. And if you have questions about it, these are administrative matters. So you're welcome to call Jackie. They're not confidential like the court's internal deliberations are. So you're welcome to call Jackie at any time, or Martha, or Pauline, and give us a heads up, ask questions. These are your contacts to the court for the committee. Looking forward very much to working with all of you. Justice Bland has come on as our liaison as well. Of course, you're always welcome to contact her or any member of the court on rules matters. So that's what I have. Chip, thanks very much.
You bet. And we should say that Jackie is more than willing to be contacted any time of the day or night, weekends. It's a 24/7 job, right, Jackie? Yeah, she's nodding her head. Yes. Justice Bland, do you have any comments you'd like to share with us?
Good morning, Chip. I joined this committee 20 years ago with Chief Justice Tracy Christopher when we were both Harris County trial judges. In my new role as Chief Justice Heck's deputy, I talk less and smile more, which will probably come as a relief to some of the longer tenured members of the committee. But I am no less engaged in the work and in the discussion that I always find very fruitful. I want to extend the appreciation of the court to all of you on the committee. The chief mentioned the extraordinary talent that the membership of this committee has reflected through the decades. And this current committee is no exception to that. And we understand that you have to put aside busy law practices and busy lives to really volunteer your time. You will find, though, that there is no other effort that you could make in volunteering your time toward improving our state court system and our rules of procedure and evidence. So for that, the court is very grateful, and I will turn it back over to you, Chip.
Thank you very much. Some of you may know Professor Lonnie Hoffman, but you won't see him on this, even though he's here, I believe. Professor Hoffman informs me that he tried to break up a dogfight and therefore is in no condition to be seen. And his recommendation to this committee and the court, don't try to break up a dogfight, apparently. So we're always glad to have Professor Hoffman with us. And I skipped over, or I maybe inadequately described the background of Manuel Bareilles, who is here. And Manuel, if you could just give us a brief biography of yourself, that would be great. And then we'll get started with our substance.
Thank you, Chip. Appreciate that. And apologies to the committee for joining a few minutes late. I was stuck on a call and urgently trying to get off. I'm a partner with Vincent and Elkins in the Dallas office. I focus on litigation with a specialty doing regulatory work, mostly for financial institutions, in addition to general commercial litigation practice. I'm born and raised in Texas. I'm from a small town in South Texas, Pearsall, about an hour south of San Antonio, right on 35. And came back, went to school out east and got back to Texas about as quick as I could after a clerkship, and have been practicing in Dallas since 2006. I started my career at Sussman Godfrey, a great firm that I'm still quite close to, and have been at V&E since 2009. Really excited to be a part of the committee. Had the good fortune of even working on a matter with Justice Bland very briefly while she was at V&E, and also am very good friends and law school classmates with Justice Blacklock. So really looking forward to being a part of the committee. And thank you, Chip, for coming back to me and allowing me to introduce myself.
Oh, yeah, no problem, Manuel. Thank you very much. Our next item of business is discussion of suits affecting the parent-child relationship and out-of-time appeals in parental rights termination cases. We have already had discussion on this topic in previous meetings, but the chair of this subcommittee is Pam Barron, and the vice chair is Bill Boyce, and they have been leading us through it, but perhaps one or both could give us an update. Pam.
Well, let me just introduce Bill real quick. I'm Pam Barron. I've been on the committee only 28 years. I'm currently chair of the subcommittee on the appellate rules. I stand in shoes that are way too big to fill because Bill Dorsanio was chair of the subcommittee for many, many years. His knowledge of the appellate rules exceeds the combination of all of the appellate lawyers I know put together. So we're sad to see him as emeritus. We also are very, very saddened by the loss of our member, Frank Gilstrap, who was a dynamic member of our subcommittee, always understood both the big picture, the little picture, and knew a lot about the Battle of Thermopylae. So we will miss him. I do want to welcome our two new members, Connie Pfeiffer and Rich Phillips, dream team members. So we're very, very happy to have them. Now I'm going to turn it over to Bill Boyce. He is the vice chair of the subcommittee, and he stepped up to take over the parental termination rule changes, and it has been a tar baby for our subcommittee and Bill in particular, but hopefully we'll make some progress today. Bill?
Thank you, Pam. I'm going to begin with the subcommittee's prayer for relief. And that is, I hope where we can get to today is a vote on final or nearly final language for the proposed Rule 306 that's reflected in the April 12th memo that was distributed for today's meeting. This topic has been discussed at multiple meetings over the last year and a half. I'm going to really try to not replow old ground. For those of you who would like a refresher, those of you who are new to the advisory committee, the background of this is discussed in the memo itself. The short version is that we are taking in stages procedures to address the right to appeal and the right to appointed counsel for indigent parents whose rights have been terminated by an action brought by a governmental entity or when conservatorship of the child is sought by a governmental entity. There's multiple issues packed into this. And for the last 2 to 3 meetings, we've been focusing on some threshold issues. One was the form of citation, which we got through relatively quickly and came to pretty quick consensus regarding the language and the need for express notice to the parent of the right to appeal and the right to appointed counsel in the situation of indigency. The next step, and the one that we've been talking about at some length, is a mechanism for the beginning of the appeal or the beginning of the appellate process. As we've discussed before, the circumstances may or may not be clear about whether a parent whose rights have been terminated wishes to appeal the termination. This may be because the parent has never participated in the case. It may be because a parent intermittently comes in and out of the litigation due to a variety of factors. Prior votes of the full committee focused on an approach that would channel this next stage into the judgment. If we're going to try to set the table for what happens next in terms of claims for inassistance of counsel, if there's an untimely effort to appeal or matters such as that, we need to have a starting point. The sense of the committee as a whole, the entire Supreme Court Advisory Committee, was to follow a recommendation by the subcommittee and channel this discussion towards what do we want the final judgment to say in these cases that will help to clarify whether the appeal is going forward or not, whether appointed counsel will continue to prosecute the appeal or not. And that led us to a series of revisions, proposed revisions to Texas Rule of Civil Procedure 306. In the memo that was distributed, the most current version of the proposed revisions, the ones that we're going to talk about today, are reflected at pages 7 and 8. There also is an additional one-page version of Rule 306. And to avoid confusion, I just want to clarify, the one-page version of the rule that you received shows an earlier iteration of the proposed rule changes with additional changes that were suggested by Judge Hoffman and Judge Rucker on behalf of the Children's Commission. Their input and interest has been very helpful, very much appreciated, and has helped to guide us towards a resolution or a proposed rule that we can present for consideration while keeping in mind that we have multiple steps left to take. So again, to avoid any confusion, we're going to be working off of the proposed rule at pages 7 and 8. The proposed rule at pages 7 and 8 reflects the subcommittee's efforts to incorporate comments from the November 2020 meeting. We talked about this at some length. A number of issues were identified. We've tried to work through them. We've tried to address the concerns that were voiced, identify a couple areas where we thought there was potential for uncertainty or confusion, and eliminate those. And so with that preamble, I would turn to the proposed draft at pages 7 and 8 of the memo that you've got and start explaining in brief the most recent changes that have been suggested. If you turn to page 7, you'll see some redlining that highlights the discussions we've had leading up to this most current draft. Below that, you'll see the current Rule 306, which already contains an express reference to suits for termination of the parent-child relationship. And so that's why we thought this would be an appropriate place to build out additional factors in the judgment to help guide this process along and deal with the underlying concern about whether an appeal is going to go forward. The policy concern that's been voiced and very ably discussed is that we're dealing with a balancing of interests. The right to parent is protected, it's constitutional, but there's other countervailing considerations, including not having litigation and appellate proceedings drag on while the futures and lives of the children who are affected are in limbo. Those are the continuing balancing of interests, along with the concern about helping the court system handle these cases in a way so that it's clear whether there is a desire to appeal, avoiding having appeals continue. It's sometimes been referred to as the phantom appeal, when it's not clear whether there is even a desire to appeal a determination of parental termination. And so that's the balance that this proposed draft Rule 306 is trying to address. So if you look at paragraph 1 of the draft that appears at the bottom of page 7 of the memo, you'll see that picks up the second sentence of the current draft. Turning to page 8. The changes that the subcommittee has recommended primarily focus on this portion of the rule. The goal was to use the judgment, have the trial court sign a judgment that sets the table for what's going to happen next in a little more of an express way. So we started out with earlier iterations. We got Children's Commission input on that, and based on the conversations in November, these are further recommendations. The main points, the redlining is not super extensive, but it does reflect some very specific points. First, you will see that the prior iteration of the rule set out a laundry list of things that the judgment would have to say. One of these options, again, towards the goal of having clarity about whether there is a desire to appeal, whether the attorney is going to continue the appointment for the appeal. One of the concerns that was expressed during the November meeting is that in part, this was implicitly making a decision about whether or not the attorney was going to go forward with the appeal or not. The related question was a concern raised by Chief Justice Christopher and others that inevitably there's going to be judgments that don't strictly conform to these requirements. Does that make them final, interlocutory? What happens then? Now, in an effort to address those concerns, we propose a revision that moves what formerly was subsection A and makes that the default and puts it in the main body of the rule. The attorney will continue the representation unless one of the following express statements appears. And then that takes us to the options that are available at that time. The default is the attorney continues unless the attorney is replaced by another attorney who will continue the proceedings, or the attorney is discharged without continuing the appellate representation based upon findings of good cause under certain enumerated circumstances. The circumstances, the four that are spelled out, are not hugely different from what we discussed last time. They're an effort to comply with the case law and statutory requisites for continued representation. The changes that are reflected here in section 2B, small Roman numeral 1, was a thought that I think Richard Orsinger had highlighted, the question about the form of service. Rather than describe it colloquially, let's just refer to the rule in an effort to avoid potential confusion. In small Roman numeral 2, the question was that the statute is really framed in terms of locating the parent. Under the theory, from a jury charge and other contexts, that every or is an opportunity for confusion. Can we reduce some of the ors here? So the thought was, does identify add anything that is not already encompassed by locate? There may be discussion that we have in the course of this meeting that identifies why we want separate reference to identification, but the subcommittee's determination was that in an effort to align with the statute and reduce opportunities for disagreements about what exactly is required, perhaps that language can be omitted. There were other suggestions or questions that were not incorporated in these red line changes. One of them, for example, under subsection B, was a suggestion about whether we wanted to say, for purposes of this subpart, good cause means the following, and change that to say includes the following. The subcommittee looked at that issue and came to a consensus that in the goal of reducing opportunities for uncertainty and future litigation over what good cause is, and to align with the statute, to the narrower formulation of means would serve that goal. If you look at page 10 of the memo, you'll see in red line additional comments and explanations at pages at paragraphs 6, 7, and 8 that in shorter version cover what I just covered. So that is the proposal that the subcommittee now brings to the full committee for further discussion. And Chip, I hope if there is consensus subject to any other wording changes that may be requested, I would hope that we would be in a position to take a vote on this proposed rule, which would then complete the first part of a multi-part assignment, and the subcommittee would move to the subsequent issues that have been identified.
Sorry, I was inadvertently muted. Yeah, this committee loves to vote, so we will vote for sure at the end of our discussion. And your presentation was incredibly thorough and terrific, and thanks very much. You have little buttons somewhere where you can raise your hand, and I've got a little button here where I can tell if a hand is raised. So if anybody wants to say something, go ahead and raise your hand. Electronically, of course. We will definitely have discussion on this, so don't be shy.
All right, I can't find the raised hand on mine, but I have a question.
Judge Shaffer, thank you.
To what extent were practitioners who are involved in this process consulted? More particular, people that appear as attorneys ad litem in these cases?
There was input obtained from the attorneys who handle these cases on a regular basis, and in significant part, that was the source of a recognition that parents may come in and out of these cases intermittently, which was one of the concerns that we had about trying to craft a rule that did not err on the side of cutting off appellate rights because a parent may have been served and may have initially participated in the case, but then dropped out or can't be located after trial and those sorts of things. So that was one source of information. And the second source of practical practitioner information and judicial insight came from the Children's Commission's input into this rule. And Judge Shaffer, I will take this opportunity to note something that I neglected to include in my introductory comments, which is that at the prior meeting, at the November meeting, Judge Hoffman participated in the discussion. I forwarded these most recent revisions to Judge Hoffman and Judge Rucker, and had received input back that from Judge Hoffman that he was comfortable with this current iteration of the rule. I don't know that either of them is on the meeting today, but I did want to note that.
Was there some discussion about the fact you're making basically the trial court attorney ad litem the default throughout the process, right?
Yes, that is the default position that's in the current draft.
And was that discussed with them? Oftentimes I've heard that, a fresh set of eyes is a really good idea when it comes to appellate appealing these rulings when they are appealed. Did the practitioners you talked to express some kind of desire that should be the default position?
To make sure that I'm understanding your question, a default position would be that an attorney is appointed, but it would be a new attorney?
No, the default position, that y'all are suggesting here is that the attorney appointed in the trial court is the attorney throughout the AAL, throughout the trial court proceedings and the appellate proceedings.
That is, yes.
And my question is, the practitioners you visited with, was that something that they thought was a good idea?
I think I don't understand there to be any disagreement with the possibility of having a new counsel appointed for appeal, and the current rule, the current draft certainly provides that possibility. The default is more aimed at the making sure that it's clear whether or not an attorney is going to continue, an appointed attorney situation is going to continue. I think there may be considerations that we address later in terms of claims for ineffective assistance of counsel and so forth that may have some impact on the questions you're raising. But I don't think that the default reflected in the current draft mandates that the trial court must have the existing attorney ad litem at trial continue, but to make sure that the right to appeal is perfected, the right to appointed counsel is perfected. That seemed to be the clearest mechanism for addressing that.
Thank you.
Okay, if anybody knows how to find their little electronic hands, go ahead and raise them, but I can't find it, so we'll do it the old-fashioned way. Who wants to speak?
Yep, that hand is under the reactions button. If you push the reactions button, it'll open up and say raise hand.
Under the reactions button.
Yes.
Ah, there we go. Oh, cool.
Thank you.
All right. Thank you, David. All right. So anybody has a reaction to what Bill Boyce has to say? Raise your hand and I should be able to see it, but who knows?
Here's one. Lisa.
Here's one hand that's raised, but I don't know who it is. There it is. Lisa. Okay. We're on the roll now. Go ahead, Lisa.
I just wanted to give a comment of support to Bill Boyce's work on this and the subcommittee's work on this. Like, I think this is a great draft, and I have some consternation about the means versus include. I probably would have been on team include and not team means. But I can kind of see it both ways. We definitely all agree that certainty in this rule is a driver. I just wondered if for good cause, like if, just appointed trial counsel was sick or having surgery or, I can think of some good cause to, I don't know. I don't know that it would be an abuse of discretion to consider those things, despite how good cause is explicitly defined here. But other than that comment, I think you've done a really good job, and I really appreciate your work on it. Because I think it's a very important rule.
Thanks, Lisa. Bill, any reaction to what Lisa just said?
That's a valid point. One option that may work is to, when we do vote on the rule, to vote alternatively on includes or means. The subcommittee's sense was that if our goal is to provide additional clarity, then a more restrictive definition would serve that better. But like everything else in this arena, we're talking about a balancing of interests. And so it may be the committee as a whole's determination that balance should be struck in favor of broader language, or we could also send it, if the committee improves, for consideration as an alternative form, and the court can look at that and reach its determination about where that balance gets struck.
Great, thanks, Bill. Any other comments? Yeah, Rich Phillips.
Yeah, just on what Lisa had said on the concern with good cause. The other thing I think we talked about in our subcommittee is those good causes are really to discharging the attorney and not appointing somebody else, to discharge and say the case is over, there will be no appeal. And so we wanted to keep that to those reasons that kind of track what's in the statute. I think something like Lisa talked about, where the current ad litem is sick or some other reason, that I think would be covered by the idea of we're replacing the attorney. We're going to discharge the attorney and appoint somebody new, either for the appeal or appoint somebody new. But the good cause in this thing is about discharging the attorney and saying there isn't going to be an appeal. And so we're trying to not have too much flexibility on that issue, just because we want to keep that certain.
Great, thank you, Rich. Any other hands? Anybody else want to?
Yep.
Yeah.
I can't find my raise hand button. My interpretation of the concerns raised by Judge Shaffer is that oftentimes people who are appointed ad litems are young lawyers who have no appellate experience. I don't practice in the area. I don't seek out ad litem appointments, but I wonder if either by comment or by language in the rule, we should let the trial court or telegraph to the trial court that it shouldn't be reluctant to substitute an ad litem that has appellate experience. Otherwise, you can have young lawyers who do this work and they're going to have shock and horror to find that they have an obligation to continue with the appellate proceeding. I don't know. Maybe that's how I construe Judge Shaffer's concerns. So that's my comment. And if David or you could expand your comments about how to find the raise your hand button, I'll try to do that next time.
There's a icon down on the right, lower right of my screen. I don't know about yours. It says reactions.
I got that. I can clap my hands. I can do a thumbs up.
No, it's under the participants button. If you click on participants, it should open a list of participants on the right. And then
found it. Say
invite, mute, or raise hand.
Got it. Thank you.
You bet.
All right. Well, cool. So now Richard Munzinger. You're gonna have to unmute.
You're muted. Richard, you're muted.
I'm in favor of using the word includes rather than means. The circumstances that can be present in a trial court are beyond the imagination of the committee as a group. Nobody knows what the circumstances are. It seems to me that sound judicial management and docket management suggests that you should leave these decisions to some extent in the hands of the trial court. There is an interest in finality. If you limit good cause to just those two grounds, I think you tie the hands of trial courts and appellate courts unnecessarily. And I think that you should leave it to the discretion of the trial court. Everybody understands, it would seem to me, that it's a serious problem involving parental rights. At the same time, if someone doesn't participate or doesn't show up, a restrictive definition, it seems to me, ties the trial courts and appellate courts' hands unnecessarily. I'm finished. Thank you.
Yeah, thanks, Richard. John Warren, and then Judge Shaffer, and then Pam.
Thank you. One of my observations when I was a trial court administrator was that the judge I worked for, when they were getting ready to do the ad litem appointments, they always looked at the experience or the area of expertise of the ad litems to make sure that they were being an advocate for the minor. So I think that's something that, as it relates to Levi's comment, I think that's something that the trial courts has to continue to take into consideration, not just make blanket appointments just because, but because the ad litem is actually going to do a good service on behalf of their clients.
Great, thanks, John. Judge Shaffer.
Yeah, I'm going to echo what John just talked about, because I know people who serve as attorneys ad litem in these CPS cases, and it's not just what Levi said is very valid. The young lawyer who doesn't have appellate experience, but it's also the very experienced lawyer who has no appellate experience and doesn't want to go anywhere near the Court of Appeals. That their practice has been devoted to the trial court, and that's where they want to stay. And so they would not feel comfortable in an appellate. Now, in that situation, they would probably move to withdraw and ask the court to go ahead and appoint an appellate counsel. And I think that can be done in this rule, regardless of what the wording is.
Thank you, Judge. Pam Barron, and then Justice Christopher.
Yeah, I just want to basically repeat what Rich said, which means was picked for a particular reason, and that is we do want to limit the options going forward. And the idea is at this point to have certainty as to whether there will be an appeal, and if there is an appeal, who's in charge of it. Time is very, very short on these appeals. You don't have time for uncertainty. And so we wanted that to be shown in the judgment, for there to be limited outs. And most of these can be taken care of by appointing a different ad litem, a substitute ad litem, if there are issues with the particular attorney who has done the trial work. But that needs to be done promptly, or otherwise the next thing our committee is going to be considering are out-of-time appeals or ineffective assistance of counsel, and all of that would feed into more problems there later. So definitely I would stress means and not includes in the language of the rule. Thank you.
Thanks, Pam. Justice Christopher.
Yes, I was just going to echo that. I apologize, but the idea behind B is that the person will not have a lawyer on appeal because of one of these 4 reasons. If a lawyer has no appellate experience, he just says to the judge, please appoint someone new under A. Any other reason, please appoint someone new under A. The B is when the judgment will say you don't have a lawyer at all. So that is the big difference. And that's why it needs to be limited to these specific circumstances.
Great. Any further comments from anyone? Okay, there are no electronic hands raised or otherwise that I can see anyway. So it's time to vote. And let me frame the vote in a way that is slightly different from the way we usually do it. Vote in favor of these changes to the rule as reflected in the subcommittee draft, unless you just think the fundamental approach is wrong and that we ought to go back to the drawing board and do something else. The tweaks to the rule that have been expressed by various members here will be considered by the court when they look at this transcript. So when you're voting yes, you can assume that if you have raised a tweak or a slight concern, that will be considered by the court. Your yes vote doesn't necessarily mean that you've abandoned your position, and we're not going to note who's voted yes and who's voted no. So everybody that is in favor of the draft that the subcommittee has come up, that is behind tab B and is also laid out on pages 7 and 8 of the memo, raise your hand. Okay, keep them up. Just keeps changing on me.
Chip, am I correct that we should raise our hand one way or the other? In other words, virtually or in real life? Okay.
Well, yeah, it'd be better if you did it virtually.
Okay, that's what I'm
be easier to count that way. Although my screen keeps changing every time that I try to count. But I think I'm on top of it now.
Chip, if you go to participants, you'll see all of the hands raised. That would be an easier count than the continuing shift in the images.
You know, thank you so much. You're absolutely right about that. So that's how Shiva and I are gonna do it. See if I get the same thing I did with the images. Okay, everybody, you can lower those hands. And everybody who is opposed, raise your hand now.
I show Bill as being opposed, and I'm not sure I believe that. Bill Boyce.
I know
I was slow on the lowering of hand draw. Apologies.
There we go.
He lowered his hand.
The ultimate bait and switch.
That would be like the dissenting justice writing the majority opinion.
Right. Okay. There, by a unanimous vote, the proposed rule is passed, and we're done with this and ready to submit it to the Texas Supreme Court. So, Bill, has that satisfied your need to vote, even though briefly you voted against it?
Upon further consideration, I think we're done with this aspect.
Okay. And the record will reflect it was unanimous vote in favor. So what is next, Bill or Pam or anyone?
Go Bill.
I think that we've moved to the next stages of this multi-stage project, and we'll bring back to the committee at an appropriate time the discussion reflected or the issues reflected on page 2 of the memo, talking about what happens with respect to untimely appeals, ineffective assistance of counsel claims, and so forth. And that opens up a new array of considerations.
Thank you, Bill. Okay, moving on to something I think will be brief, an update on the briefing rules. And Pam, do you want to give us a brief update on the briefing rules?
Sure. We don't really have any action items today, but our subcommittee could use more guidance on this project. So I'm glad we have the chance to kind of update where we are and what we've been generally tasked with and what we've done so far. You might remember last year the court referred a lot of very specific items to the Appellate Rules Subcommittee, including things involving the briefing rules. We went through all of those at our late August meeting last year. If you were there, you can remember that we spent probably a half a day, maybe more. And Chip said we took more votes than in the history of the committee on these matters. 6 of them related to the briefing rules, and that was in the materials, I guess that was included with the agenda earlier this week. And we had 6 specific items that we were told to consider. One was to remove the paper copy requirement for documents that were e-filed in the Texas Supreme Court that passed the committee without dissent. We were asked to consider whether to remove the requirement to include the Court of Appeals judgment in the appendix to the petition for review. That, for some reason, was more controversial than radically changing the supersedious rules, and it did pass by a close vote of 13 to 12 with the chair not voting. Chip. The third thing we considered was whether to add a reasons to grant section to the petition for review, and that was very popular. It passed 21-2. Then we were asked whether to delete the statement of jurisdiction section in the petition for review and brief on the merits, and we recommended that change, and it passed 15-8. We were asked whether we wanted to create a standardized form of citation to the record like you have in federal appellate court to permit hyperlinking. And what we learned is that the technology is not yet there in the Texas state courts because we have 254 different counties with different systems. And so we deferred that until technology catches up, and we're reluctant to adopt a uniform system that would have to be changed later if it was not compatible. Then we were asked whether to add a requirement in the Texas Supreme Court briefing to require citations to where the error was preserved in the record. And that did not, the recommendation was not to do that, and that passed 22-1. Just because of the complexities in the Supreme Court with cross appeals or whatever, of actually pinpointing that in a very short way. It's usually, and it also would cause way too much attention and fights over preservation when that's really a collateral issue most of the time in most appeals. And finally, we were asked whether we should remove the certificate of service requirement in documents are e-filed because our e-filing system now generates that automatically. And that was a general favorable discussion to going that way, but there was no vote. So then later in that year, I was contacted by the rules attorney saying that the court wanted our subcommittee to take a more robust look at the briefing rules. And I owe an apology to Jackie because that day was a particularly grumpy day for me during the pandemic. And so she got a little more pushback than she probably deserved. But I did commit on behalf of the subcommittee to do 6 things. And some of those things have happened and some of those things have not yet. But the first thing I said, I would contact the Appellate Rules Subcommittee of the Appellate section of the State Bar to get their input. And that was actually very helpful. because last fall, that subcommittee completed a survey of the entire membership of the appellate section of the state bar on identifying particular problems with the Texas Rules of Appellate Procedure. If you don't know, the appellate section has grown quite a bit, and it is now considered a large section of the State Bar of Texas. It has over 2,100 members. They did do a full press outreach to the members. They had several blast emails. They posted it on their Facebook and Twitter feeds. They included it in the quarterly publication, the Appellate Advocate. And what was interesting is that they got very little response. So one conclusion that they drew was maybe it's the devil we know is better than the devil we don't, or if it ain't broke, don't fix it. But among the rules, they touched on a variety of things, but only one addressed briefing, and that was whether there should be a specific rule addressing post-submission briefing with things like word count limits, time for filing, whether or not leave is required to have a more uniform practice, because that does vary among all 14 courts of appeals and the Texas Supreme Court. Anyway, the appellate section sent its report to the court last fall, and none of those items have been specifically referred to our committee at this time. The second thing I committed to do was to contact the State Bar Court Rules Committee to get their input. And they're a great committee because they operate in a more free-ranging way. They're welcome to go out and find problems, and they also respond to letters that come in to the bar that complain about particular rules or practices. They currently have only one item on their radar that relates to the briefing rules. And as a matter of coincidence, it has to do with post-submission briefing. And they've had a comment of somebody who thinks that the Texas courts should follow what are contained in the federal rules of appellate procedure, which narrowly limit the length, timing, and so on and so forth of post-submission briefing. But they are in very preliminary investigation of that rule, so they have not produced a recommendation one way or the other and have not forwarded anything to the Texas Supreme Court at this time for its consideration. The third thing I said I would do is I would talk to Evan Young, who has been working with the court for many years to try and convince them to change the petition for review process to more closely resemble what we see at the US Supreme Court. And if you remember our December 2020 Deep Thoughts meeting, Nina Cortell and Evan Young did a fairly long explanation of that process, and this group had a really good discussion on that, and so that's gone to the court, and nothing has been sent back to us to think about. The fourth thing I said I'd do is I would ask the court for more guidance, and in particular, where they had particular improvements or thoughts or problems that they wanted us to look at. I did that in an email, but did not get further guidance. The fifth thing I said I'd do is I would contact the chiefs of the courts of appeals to get their input on any problems they were seeing. That I have not done. I'm wondering whether it would be useful. It'd always be useful to talk to them, but after the section, surveyed 2,100 members, many of whom include appellate justices in our state, whether more outreach in that area is needed. And the sixth and last thing I said I would do would be to ask members of this subcommittee to email me any concerns or problems they were having with the briefing rules. And I apologize, I have not done that, but right now I'm asking you to do that if you see problems or corrections that you think need to be made. So what we really need at this point is just further guidance. I mean, the appellate section has basically said there's no great hue and cry for change to the briefing rules. I think we're all kind of used to them. Obviously, everything is capable of improvement. So if we had more guidance from the court and this committee, we're happy to go forward as everyone sees fit.
Thanks, Pam. In terms of guidance from the court, I'll start at the top and see if the chief has any guidance to give you.
Well, not right this second. This is very much a joint effort on the court, and at various times, different people have asked that we consider different things and have added to the list, and then have at the same time said, oh, well, we're not really concerned about that. So I think Pam's done a lot of good work on this, a lot of thorough canvassing of stakeholders, but the best I can do is report back where we are and see what my colleagues say.
Well, I'll go near the top then, if not right at the top with the Chief Justice Bland.
Well, what he said. No, we'll look at the State Bar report and track that down and go through that, and then also this issue of whether we should request briefing on the merits only after the petition's been granted. We probably would need the committee's help with that. So probably what we'll do is put together a list and make a formal referral to the committee after consultation with the court.
Right.
That'd be great, Justice Bland. And if for the newcomers, the way it ordinarily occurs is that the chief will send me a letter outlining what the court wants us to review. I will then refer it to the appropriate subcommittee, and then the subcommittee will do its work and then report back as Pam just has. So now to the real power behind the throne. Jackie, is it true that Pam was grumpy when you called her with a totally reasonable request? And do you want her to do anything that she hasn't done?
I plead the fifth. No, she was fine. And we'll get together a list. I hadn't seen that appellate section report, so I'll try to dig that up.
Thanks, Jackie. Martha? You got anything?
No, I defer to the chief and Justice Bland.
All right. And Pauline, the real power behind this whole operation here. Anything from you?
No, I don't have anything.
Okay, thank you. Well, we will then defer this pending a further assignment from the court. So we will not put it back on the agenda for the next meeting and go from there. The next item is Professor Carlson's. And for those of you new to the committee, you'll see the reference to deep thoughts, which Pam just mentioned a minute ago. That was a phrase that I coined a number of years ago. We thought that in the December meeting every other year, before the legislature went into session, we might devote our meeting to what I dubbed deep thoughts. That is, we would consider things that we might recommend to the court that would improve the justice system, broadly speaking. We've had members of the legislature address us. We've had members of the legislature just sit and observe. And we've had ideas come in from all sorts of places. We've had speakers from out of state. So when we refer to deep thoughts, it's that meeting every other year, right in advance of the legislative session. So with that said, Professor Carlson, anything to report on your subcommittee's jury rules?
We don't have a formal report, Chip, but this was just recently referred to our subcommittee. And the letter of referral from Justice Hecht asked us to review rules 216 through 236 because they're outdated and don't reflect current practice, and to draft proposed amendments for the court's consideration. And Justice Hecht asked that we interface with the Remote Proceedings Task Force in removing any barriers to remote jury proceedings. So I wasn't quite sure how that worked together. And I contacted Justice Christopher, who chairs that committee. And she advised that, I don't want to put words in your mouth, Judge Christopher, so correct me if I'm wrong, that the task force really isn't working on suggestions for jury trials. They're working on identifying impediments to continuing remotely working, the court working remotely with attorneys on hearings and perhaps trials. So then I chatted with Jackie, our rules committee, and Jackie was kind enough to remind me that Bobby Meadows' subcommittee, which had looked at statutory changes dealing with expedited trials and other matters, had in their memo to the full committee pointed out that one of the changes in that statute requires the county courts to have a 12-member jury for any case where the amount in controversy is over $250,000 and the county court at law has jurisdiction, unless the parties agree to a lesser number or it's waived. And of course, our current rules don't really reflect that. And Jackie advised me that, I'm going to look at her email, that she had spoken with Sharina from the clerk's office, who reported that our rules don't reflect current practice, that they're mostly pre-World War II rules, and that most clerks don't follow them. They look to the government code and their county's jury plan. So I'm delighted that John Warren is on our committee, and he hopefully will give us some input, but I just thought it would be helpful to our committee to get a little more guidance and then to get input from the full committee on any problems that you see with our current rules, and then we can perhaps more finely tune our task and report back at the June meeting.
Thank you. Justice Christopher.
Yes, we had not actually been asked to draft any rules yet with respect to remote jury proceedings or even best practices for remote jury proceedings. But if the Supreme Court tasks us with that, we will work on that. What we spent our time doing for these first few months was trying to find where there were statutes that that would prevent things like that. So that's what we spent our time doing, just in case, as Justice Hecht said, the legislature is working on some legislation that might help us in this area. But we certainly have people on the task force that can help with best practices on remote jury trials. But we haven't looked at it in terms of revising the current rules.
Yeah, it seems to me, Justice Christopher, that there are two parts to this. One is the remote jury trials, which will perhaps be more complex than the other, just looking at the rules and bringing them up to date, recognizing that World War II ended some time ago. And so rules prior to that might be outdated and in need of reform. And I would think that subject to the court contradicting me, you would want to proceed on both tracks, but obviously you'll be limited to some degree on the speed with which the task force is moving. So my proposal, Elaine, would be to do it on that basis, and we would bring this back for our next meeting. and go from there. We have a couple more comments though, and let me see who raised their hand first. Can't tell. So we'll go to Justice Christopher again.
Oh, no, I'm sorry. I forgot to lower my hand.
All right, then John Warren.
I think Judge Miskal her hand was raised before mine. I'll be a gentleman and let her go first.
So I think there are two things here. One is our task force absolutely identified these rules as impediments to remote proceedings, and universally everyone agrees that they're outdated and don't match current practices. So I think in general we need to work on new rules for normal jury trials anyway, and I would suggest that work can go ahead and get started. As far as the legislature, I testified day before yesterday in the House Committee on remote jury trials. That is an area that's actively being debated, and so I don't know that we should spend any effort thinking about remote jury trials until after the legislative session.
No, that's a fair point. Thanks. And I'll have something more to say about that in a minute, but John Warren.
Thank you. As it relates to virtual proceedings, I'm going to quote Chief Justice Hecht that when he says that we will return to normal, but virtual proceedings will be part of the new normal. And while I agree with that being something we consider later on, but we have to look at the efficiencies that new processes and new technology that's available to us and what that actually means. It's particularly when it comes to cost per disposition of a case. If you have out-of-town participants that need to, out-of-town witnesses or that may need to participate in a trial, the opportunity for them to do that virtually adds value to this process. But we have to look at the foundation, but that is something that we should consider, because it would be actually important to proceeding with the case in a timely manner.
Great. Thanks, John. Any other hands?
Kathleen Stryker.
Yeah, Judge Stryker.
In Bexar County, we've been having a lot of remote jury trials, and the one thing I think everyone kind of agrees on, and we did a bar survey on this, is that everybody wants to go back live, but we found locally, and what we're going to do as we start our live jury trials in June is continue jury qualification and selection virtually, because our experience in the pretty big number of virtual jury trials we've done is the jurors love it. They don't want to come here and find a parking spot. They don't want our bad Wi-Fi. They don't want to not have a seat because there's 500 people in one room. And so if nothing else, what I've found is I've qualified some panels is that Rule 224, 225, 226, 226A, none of them, and the instructions, they're all not applicable. So I've been kind of just rewriting them as I'm talking, because we're qualifying jurors remotely. So I kind of envision that at some point, even if we go back completely live, that the jury qualification procedure might end up remote for a long time. And so to the extent that we're going to look at any rules to address remote, those might be the ones that we start with, only because I do think that's the most logical part that could stay remote possibly forever, because everybody can give their exemptions and their felonies and their excuses remotely pretty easily. And then we take the panels and have them report live. That's what we're going to do here starting June 1st.
Chip, you're muted.
Hey, Chip, it's Jackie. You're muted.
Ken, you're muted, but now you're not.
I'm not. Are you calling on me?
I am.
Okay, I didn't hear it.
Yeah, that's because I was muted. Nobody told me to.
Well, you outmuted me.
Yeah, I outmuted you.
So I just wanted to make a very brief comment, and that is, I think it's important that we get some direction and have decisions made as the extent to which we're talking about rules for a new system that would promote real uniformity. That is uniformity county to county and statewide practice, or whether we continue to facilitate what is largely a decentralized and even idiosyncratic system that differs in terms of how it operates from the perspective of jurors and litigants county to county. On the one hand, you look at trying to adopt best practices and pursue a more uniform model. The other hand, you continue with more of what we currently have, just trying to facilitate certain practices. And then second, if we do promote more uniformity, then there's a question of the extent to which there should be more centralization, including the possibility of more centralized support and maybe even availability of resources. My experience is there's a significant difference county to county of the infrastructure that is available to support more modern and technologically dependent proceedings, and a big difference in terms of just resources in general. And I think that has to be taken into consideration. I don't know to what extent there is a potential role for the Office of Court Administration or of the availability of additional resources that might be available on a centralized basis and not available on a decentralized basis. So just a couple of thoughts.
Great, thank you, Kent. Judge Peoples.
I have a question for those who have been doing this and those who have been studying virtual jury trials. Is there any emerging consensus on whether you can force someone over an objection to try a jury case virtually as opposed to in person? And if there's no emerging consensus, what does everybody think about that? I think that's going to be a difficult question for this subcommittee.
So that's actively the question that's being debated in the legislature on this bill right now. And so that's why I suggested we wait to work on any virtual jury issues until we see if anything happens in the legislature or not, or what it is.
Anybody have any views on that issue? I know the legislature will control if they pass a bill, but does anybody have any thoughts about Judge Peoples' question?
I would defer to San Antonio because I know they've done more than we have in Collin County, but my opinion and the opinion of all the trial judges that I've talked to that have done them, which has been, I think, as we've heard, 50 fully virtual jury trials everywhere from rural West Texas to Austin to San Antonio, Collin County, we've done them. They work, and I think every judge and participant that you talk to that's actually done them has found that they work. And as judges, we all know that our judicial system and legal system can't depend on the agreement of the parties because they already can't agree. That's why they paid their jury fee and they're having a jury trial. So the concern among the judges that do these is, as you heard John Warren say, it's a large benefit to people coming from out of state for their case or jurors or whoever it may be. But if you let someone object to it, it becomes a litigation tactic. And the person with big pockets can afford to set a bunch of stuff in person that the other party can't afford to travel to. And so I believe the emerging consensus from the judges that actually try virtual jury trials is that if it is based on consent, then none will happen.
Great, thank you. Robert Levy.
I do want to suggest that we travel very lightly and reluctantly in terms of changing rules that would require parties to participate remotely if it's something that in their determination they feel is not in their best interest. the fact that you have a witness who's remote and you don't have the opportunity to be there and really judge their reaction, to understand what they're looking at, could have a significant impact on that witness's credibility. And if you have a remote witness and then other witnesses who appear in person, that too will have an impact. And I think that the ability to obtain justice will be significantly impacted. And there might be positives, but there could very well be negatives. And trying to assess the system through a pandemic environment, I think, is probably not the best test case for whether this is a good and significant change in how our justice system is administered. And so I'm very reluctant and concerned about changes that would be forced on parties. I do understand Judge's comment that if you make it voluntary, then it won't work. But the reality is we have rights as parties, including rights to choose to be before a jury. And if, you know, those types of rights are ones that should remain with the parties. And it could be that this one as well should remain with the parties.
Thanks, Robert. Kenan.
On remote proceedings, I want to touch on something that Judge Stryker referenced, and that is having to kind of edit, if you will, the jury instructions on the fly for remote jury trials, because what we have on the books now does not account for remote proceedings. I will say that in Travis County, I know of at least one judge, Judge Karen Crump, who has presided over a remote jury trial and also done a lot of work in that space and preparing the court to preside over remote jury trials. She too has modified the standard jury instructions to account for the fact that the proceeding is remote, and therefore some things in the instructions need to be modified. When I heard Judge Stryker say she's done the same thing, it made me think that when we are ready to think about changes to the jury instructions, it would be worthwhile to find a way to poll the judges around the state who have presided over remote jury trials and have used instructions in doing that worked, that didn't work. And I bet the input we would get from them would be invaluable, including the input from people on this committee. In regard to whether remote proceedings can be mandated or not, I hope that when we discuss whether we will require remote proceedings in some cases, we won't lose sight of the fact that remote proceedings do increase access to justice for many people. There are people with day jobs that they cannot leave for an extended period of time in order to go to court to attend a hearing. There are people with dependents, they can't leave at home. And as a result, they have limited access to justice in regard to getting to a hearing and being at the courthouse for however long it takes to be reached and to have their case decided. There are people with disabilities who can't get to certain courthouses and attend hearings. And I really just want us to be thinking about how remote proceedings have increased access to justice and their potential to increase access to justice in the future. Of course, we don't want to go too far. Of course, there are certain cases where we need to be in person, not suggesting otherwise, but I just don't want to lose sight of an opportunity we have here to really increase access to justice for people. In regard to the task at hand, I think it would be really helpful to know what the court wants to see from us in regard to suggestions for improvement beyond the remote proceedings concept. By way of example, in this set of rules, there are several masculine pronouns referring to parties, referring to attorneys, referring to witnesses. And I think on the whole, it would be helpful if our rules were updated to not have simply masculine pronouns. There are things in the jury instructions now that refer to social networking websites, including MySpace. I don't know about all of you, but I haven't used MySpace ever, and I don't think many people are using it now. And so there are some outdated references to technology that I think we could tend to in this updating process, if that's something the court wants us to do. So I go back to what Professor Carlson asked for at the beginning. If it would be worthwhile to you, Chip, if you think it's worthwhile that we have a broader conversation about areas of improvement that we perceive in this particular set of rules that are needed. Thank you.
You bet. Thanks, Kenneth. Marcy.
Well, I agree with Kennan's points. I think she said them very well, so I won't restate them. I did want to offer that I am working with a panel of judges from across the country who have been conducting jury trials in their courts. One is a South Carolina federal judge. One is head of the Indianapolis courts. And one is from Nevada. One is from LA. And then Alan Albright, whom we all know from the Western District of Texas, who's been conducting jury trials. And so I think it's going to be a really interesting conversation. I've been collecting their practices for how they're conducting the jury trials. And we had a discussion yesterday with a lot of really helpful information. And I think it is worth passing on that information. So I'm happy to forward these materials to whoever would be working on these issues. I do think it's worth, at least talking about it and getting some ideas and game plans and best practices, et cetera, in mind, because this is going to be with us for a long time. And I would also do a shout out that the program where the judges are going to appear is next Friday from 10 to 11:30 on the ABA tips. And I'm co-chairing, full disclaimer, I'm co-chairing that program. So I would really love to see everyone sign up and pay for it. It's not very expensive and it's going to be a terrific program. And that's just one of the 4 panels that is going to be outstanding. Another one is Chad Baruch's panel on ethics. And if you need an hour and a half of ethics, that's probably the most entertaining way to get it.
Great. Thank you, Marcy. Jim Perdue.
I was just going to address Judge Peoples' question, although Judge Miskal's already addressed it and acknowledged kind of the issue here, Judge. There are spending a lot of quality time under the pink dome. Judge Miskal keeps getting to testify via Zoom, whereas I apparently have to live in Austin reluctantly. But there's competing bills. There's a Senate side bill. There's a House side bill. We were very late into the evening on Wednesday on the House side bill. I think there is a dichotomy developing in the legislation regarding remote proceedings versus remote jury trials. There is certainly not consensus on jury trials. And I just wanted to say that it's apparently an issue that can even bring me and Robert Levy together. So we are not in favor of mandatory remote jury trials, and that tells you the scope of the issue. But I think that we'll see a legislative mandate come out by June 1st, which will end up requiring this committee to visit, and Judge Christopher is ahead of the curve on that with her task force. But when it comes to the jury rules, they certainly merit updating, but a rewrite of the jury rules until you get that kind of legislative direction is maybe a little premature because you may have 2 tracks.
Great. Thanks, Jim. And Jim, I noticed the very elegant solution that you have for the title on your Zoom box. To Kenneth's point, rather than saying Purdue and son or Purdue and daughter, you say Purdue and kid. So that's a very neutral way of doing it, which is great. Justice Christopher.
Well, I'd just like to point out that the Rule of Judicial Administration 7 already encourages district and county court judges to use telephone or mail in lieu of personal appearances by attorneys for motion hearings, pretrial conferences, scheduling, and the setting of trial dates. So I definitely think most lawyers that I've talked to really like the remote proceedings for those sort of actions. That, instead of going to the courthouse and waiting 3 hours, they can just wait in their office until it's their turn for their hearing. I do think that the jury trial is a much more complicated question. I think it's great that Judge Stryker was talking about the qualification of the big jury panel being done remotely, because that is, you know, a big use of time that could be done remotely. I mean, it's already basically done remotely in federal court. You know, they send you a questionnaire. I just filled one out, frankly, to see whether I qualified to be a juror in federal court. So I do think that even if the trial itself is not remote, there will be certain aspects about jury qualification that could be done remotely.
Thanks, Judge. Kim Phillips, you had your hand up, but now maybe you put it down. I'm not sure.
I was just aligning with Robert Levy's comments, and I do have, you know, concern about being mandated to a remote jury trial. And I would just, you know, however it comes out, I think we have to remember that there could be complexities too, right? And so we had a situation where we had a remote trial about 5 months ago, albeit a bench trial, was something that would have lasted maybe 10 days live. You know, 6 weeks into it, I'm like, what is really happening? So I just think there are a lot of complexities that have to be considered, and not every case is going to be suitable for a remote jury trial. And I wouldn't want to find myself in a situation where that was forced on me.
Great. Thanks, Kim. Orsinger, you had your hand up, but now it's down. And do you have anything, Richard Orsinger, do you have anything you want to say?
Most of what I said was going to say have been said. I'll say that the local chapter of the American Board of Trial Advocates, which is a group of lawyers with extensive jury experience, went through a email storm, not a Twitter storm, of opposition to forced jury trials, remote jury trials. But we recently did a panel discussion for video that's going to be mailed out in an electronic email to our local chapter, but it's going to the ABOTA chapters all around Texas, and I'll be happy to send it to anyone here. We did a 30-minute interview with the chief jury clerk about the way that she assembled the group from which the individual panels would be board-ired. And she was very positive about the fact that people were much more receptive to participating in the jury process than if they had to come downtown. Comments already been made today. And then we had a panel discussion with Judge Cynthia Chapa of the 288th, who had just conducted, she's conducted 2 Zoom jury trials, one the previous week, and we had 3 lawyers on the panel. One had conducted a bill of review jury trial, which has got to be one of the most boring things you could possibly try. The other one had a family law case with a pro se litigant. And the third person had had a non-jury trial in federal district court where it was partially Zoom and partially in person. And I'll have to say, I was a moderator of the panel. I've done non-jury hearings by Zoom, but no jury trial. They were all very positive about the experience. And so I think there's a lot of opposition because it's so different from anything we've done before. And yet in some ways it's not so different, because some of us have had people testify by telephone or people testify by video deposition. And so I think it's premature for us to debate the issue of whether people should be required. We ought to let the legislature tell us what their thinking is or what they fail to arrive at. But I personally think that people who participate in the non-jury components are just thrilled with the efficiencies and the conveniences associated with non-person or remote court proceedings. And I think there's going to be a lot of money saved, and the clients are going to like it. So to me, we could talk about what the rules would be for non-jury, because I think they're on the way. I mean, I think that's coming. But as far as jury is concerned, the legislature may completely kill that, or they may mandate it. And so to me, I think we're getting ahead of ourselves to be debating that. Thanks.
Thank you, Richard. Lisa Hobbs.
I just wanted to note that as part of my role in the remote proceedings task force, I either made the wise decision or the poor decision to ask that an email be sent out to every member of the litigation section of the State Bar of Texas, seeking comments. My email was worded specific to the actual mission and goal of the task force, but what I received back over probably a 2 or 3 week period went far broader. So some of the comments that I received about remote proceedings, and the specific question was any rules or statutes that prevent barriers to remote proceedings. Those questions that actually were on, or those answers or comments that were on target to our mission have made their way to the full task force. But there was a lot of comments that were just kind of broader opinions on the questions we're talking about this morning, the good and bad of remote proceedings, the should it be mandated, should it not? And I am happy to collect those comments and emails and send them on to Jackie or Elaine. Some of them aren't really necessarily just what is my position on it. Some of them go a little bit deeper in, but they were still outside the scope of the actual question that the task force was asking. But either way, I think it would be helpful for me to gather those comments and send them along, and I'm happy to do that.
Thanks, Lisa. Judge Miskal.
Last word, I just want to speak for self-represented litigants. So lawyers are comfortable in courtrooms and they want to be there. And as a judge, if I have a case with 2 lawyers who want to be in the courtroom, I'm happy to accommodate that. I think I heard David Slayton testify on Wednesday that 8 out of the 9 million cases that are filed are pro ses, and they're in justice and municipal court. So I know that in my court, I have done over 250 trials on Zoom since last March, and I would estimate that a third or fewer of my cases have 2 lawyers on both sides. So again, I don't know if there's any representatives for self-represented litigants on this committee. And if there are not, I'll volunteer to be the representative for the self-represented litigants. But I just want to make sure that we realize that the cases that all the very qualified and experienced lawyers represented on this committee work on are not your average case that we see. So please keep in mind our system serves a lot of people who are not usually represented by great high quality lawyers at all times. And so keep that in mind as well as we debate the pros and cons of virtual trials.
Thank you very much, Judge. A couple of additional items. One, these subcommittee assignments are fluid in the sense that if anybody has got an interest in serving on a subcommittee that you were not assigned to, by all means, jump in, just let me know so I can keep track of who's on the subcommittee and who is not. So we'll do that. Nina Cortell had a comment that she wanted to make, and I hope she's still on the call. And if she is, now's your time, Nina.
Thank you, Chip. But I also note some hands have been raised. I don't know if you want to acknowledge those first.
I didn't. I see one now. Judge Estevez. Judge, you got the floor.
Well, you can go to Nina first. It's fine. The comment that Judge Miskal just said is, I just want to echo that. I've never had so many participants in our cases since we started the remote proceedings. And that's because of all the family law I do and all the pro se divorces I do. Both sides will appear. They may appear in their car. They may have a hard hat on. They're in North Carolina, they're in New Mexico, they're all over the states of, all over. And people that I've had their children for the last 10, 12, 14 years are appearing for the first time because they didn't have to fly to Amarillo. And so it's made a huge difference for those pro se and also just indigent litigants. So we need to remember that. I do think we should have a rule to allow the remote hearings. I don't have an opinion on the jury trials. I've had so much, I was gonna start the remote jury trials, but we're already back open. Our numbers got so good that we're actually been trying two or three cases, jury trials a week between our two courthouses. So we're back in person, or we would be fully remote by now. But hopefully the other numbers will come down throughout the rest of Texas. We were the highest numbers, and then we were the fastest vaccinated population in the state of Texas. So hopefully we will be the herd immunity for y'all and a little bit of hope for you if the variants don't come get us. But I just want to echo that we need to be looking out for those indigent people. I don't need to be their representative. I'm everybody's representative, but that's all.
Great. Thanks, Judge. John, you have been added to the subcommittee. So thank you for your volunteering for that. And any comment?
Yeah, my last comment I have is that we can't just assume that as we come out of this pandemic that it would be business as usual, because I do believe that this has been a lot of information, this dialogue. I would hope that we would have kind of a roundtable discussion to weigh the pros and cons on the future of virtual proceedings. Understand that we still, in Dallas County, we've had very few jury trials or bench trials. And so as we come out of the pandemic, we're going to be behind, or should I say there is a need to catch up on the number of trials and other proceedings that we have not gotten to, where we actually have individuals, litigants who is actually waiting for a resolution to those cases. So we have to figure out how we are going to do that. I think there should be parameters around a in-person jury trial if there's a capability of having one, and if the jury is willing to participate and the litigants are willing to participate. And I think that should be the benchmark for the decision, not necessarily the attorneys. And I can't remember who mentioned the fact that you have an attorney comes down and he's waiting in the courtroom. He's there several hours for a 30-minute hearing. Will he bill his client for 4 hours, or will he bill his client for 30 minutes? And so those are some of the things that we have to take into consideration. What's actually not best for us members of, or should I say, officers of the court, or the attorneys that represent their clients, but it's more so what's going to benefit the clients and what's in their best interest. So I think there's a lot of dialogue that needs to take place as it relates to the new normal in a virtual environment.
Great. Thanks very much, John. By the way, I noted that our agenda inadvertently left off some names of this subcommittee, but we'll get that corrected next time. Professor Carlson.
Yeah, I just wanted to mention that in preparing for this meeting today, I read the litigation section advocate, and it is called Pandemic Perspectives Looking Over the Horizon, of which our own member Lonnie Hoffman is, of course, the editor of this fine publication. And I was taken back by the trial lawyers who kind of shared Robert Levy's and Jim Perdue's perspective that there's a real issue of judging credibility of witnesses when you're doing it through a Zoom Brady box little square. And you have to look at the process, I think, and weigh that against the efficiencies. So I just wanted to throw that in and commend that publication. Thank you.
Thanks, Elaine.
Thanks, Professor Carlson. Judge Salas Mendoza.
So I just wanted to add to the comments about access to justice and access to the courts. It's my understanding from David Slayton that the panels that are being seated remotely also have greater diversity. And I think that's one of the things that, that we struggle with statewide. And so I think that's a good thing, and one of those benefits of doing remote proceedings, or at least seating juries remotely. And then being new to the committee, I'm gathering that we don't want to do all this work. There's a lot of work that goes into any changes for any one rule. But I guess the idea that even if we couldn't force remote proceedings on lawyers, that they wouldn't happen, that may be true. But I still think that there should be rules about how those remote proceedings should occur if they do happen. I do think that there will be some lawyers who've seen the benefits and will want to have a remote jury trial, and that we should have rules that are consistent. And then I also think the idea that somehow we'll come out of this pandemic and there will not be another emergency is not true. We could have any kind of other emergency in which we'd have to revert to some of these things that we've learned during this pandemic. And it would be a shame not to take advantage of all that's been learned by those judges who have been doing remote proceedings and codify them in a way that they could be better used should we find ourselves in this situation again. That's what I want to add.
Great. Well said. Thank you very much, Judge. All right. If there are no other hands that I've missed, and I'm looking intently to see if there are hands, and I don't see any. So Nina, you get to go next.
Thank you, Chip. I just wanted us to take a moment to acknowledge the contributions of Judge Ruben Reyes, who sadly passed away in December, as I understand, from COVID. Those of you certainly on the Judicial Administration Subcommittee, but the committee generally who have served previously will remember that Judge Reyes was an ardent advocate for specialty courts and for the roles that our judges play in those courts and how important that is. And specifically, you'll remember that the task we had was evaluating the ex parte communication rule in the specialty court context. And in that regard, I believe Justice Heck told us to talk to Judge Reyes, and it was our great pleasure and learning experience to be educated by him and informed by him and guided by his passion. And then the committee as a whole will remember that he spoke, I think, for the better part of 30 minutes or more by telephone with us at one of our in-person meetings before the pandemic. And he was just a wonderfully inspiring judge who served our system in so many ways. And I just want to take a moment to acknowledge. And really the reason I even know is because Chief Justice Heck mentioned Judge Reyes at the conclusion of his State of the Judiciary, which I also commend to all of you. It's a wonderful presentation if you haven't already seen it. But at the end, he talked about several of our judges who we lost to COVID. And I was very saddened at the end of the presentation to learn that Judge Reyes was among them. But I certainly want our record to reflect not only his great service to our state and his community, but also to this committee. Thank you.
Well said, Nina. Thank you so much. And he was a terrific guy, and we're going to miss him. Tom Riney.
I just wanted to echo what Nina said as a lawyer that appeared in front of Judge Reyes many times. I mean, sometimes he ruled against me, sometimes he ruled for me, but never once did I walk away without feeling that I had a very fair consideration and a very thorough consideration of both sides' arguments. He was a great one, and he will certainly had a great loss with his passing.
Yeah.
Thanks, Tom. I've already broken one of the rules that I told you about not 90 minutes ago, and that is we're not going to take a break this morning and then come back. We have completed our agenda, so when we break now, we're going to break for the rest of the day. This is very unusual. I can't remember when we've gotten done before lunch, but I'm a firm believer in getting to our business, discussing it thoroughly and not shortchanging anybody. But when we don't have anything more to do and anything more to say, not just hanging around for the sake of hanging around. So unless somebody else has additional business, we'll bring this jury rules matter back on June 18th, which is our next meeting. And we'll try to get you an agenda well before that, so everybody knows what we're going to be talking about. And again, welcome to the new members, and welcome back to the old members. And